Good morning, everybody. Welcome to the special recording for the Property Law Alliance with specific regard to the Alert Level 4 regulations that were released last night. With me today, I've got Silna Steyn of SSLR Incorporated, as well as Bruno Samau of Bruno Samau Attorneys. Welcome, guys.
Hey.
Thank you. Good morning.
To get started, obviously now we are going, this is the last official day of level 5, and we're going into level 4 lockdown tomorrow. The regulations were released last night, and obviously there are plenty of questions about the interpretation of them and the understanding of them. First things first, with regards to movement of people, specifically, are you allowed to move your residential premises? How would be able, are you entitled to do that in level 4? Because you weren't entitled to it in level 5. What is the standing point now?
Yes, so the regulation still says that people need to stay home unless they travel to get medicine or medical assistance or essential goods, food, those kind of things. And essential goods are a bit wider at this stage, but not wide enough to allow movement. So we will elaborate on this much more, but the easy direct answer is people are not allowed to move.
Sure, fantastic. Then with regards to certain tenants, you know, people aren't allowed to move houses. There's not anything in terms of that. What is the standing point now with level 4? Is a tenant allowed to move house to another premises? What is the standing now? Bruno, I don't know if you maybe have an answer for us.
So a certain amount of relocation was provided for in the regulations. And this is a conversation that Silna and I had earlier on as to how to interpret this. So long story short, it does allow for a person to return to their place of residence if before the lockdown, for example, they moved in with their family in another province. So this does allow them to cross provinces to get back to where they were supposed to be, their place of residence. Now, the purpose of this, or at least from reading this, it uses the word return. So we had the debate as to whether people could now move into new premises. And definitely not new premises, because it does specifically say return. And during the press conference yesterday, the intention of this was to get people back to where they were supposed to be, because they didn't anticipate that the lockdown was going to go for this long. People that entered into lease agreements prior to this point, again, the return kind of implies that you'd have to be in possession of the property. So the fact that you had a lease agreement and you should have moved in on the 1st of April, we don't feel it's quite enough to justify the use of the word return, or the reliance on the word return. So I think for the most part, this is just to get people back into their places. It does specifically say if they need to move back for work. In those instances, the regulations do allow for accommodation for those persons that are essential services and require a place of residence within the area that they need to work at. But I don't think the tenants can just, short of that, the tenants can just move around at will.
Okay, fantastic. Silna, do you have anything you want to add?
Yes, just to echo what Bruno is saying, we did argue the word return at length, and I think it's something important to mention. We were trying to see if there is a way for somebody to exactly as Bruno said, if he had a lease agreement signed prior to lockdown, does that mean he can move to that premises he signed the lease agreement for? And unfortunately, the word return will imply that he was there before. And accommodation for essential service workers, I think it's important to know that this is just the person that went home, say for instance, to his family in Limpopo, can return to Gauteng, and a guy that has a new job and he has to move to a different place, accommodation does allow for that, but it will be in the form probably of more temporary accommodation in the form of an Airbnb or something like that, where somebody can remain potentially even in isolation if he was in contact with a high-risk person. Bruno, I think that's what
Absolutely.
we've agreed to, right?
No, absolutely, absolutely.
Fantastic. Then obviously we have heard of these permits being granted for people to actually move residences. What will happen then? They are permitted to move, but for non-essential workers such as agents, how would they be able to do the inspections, the handover of keys? What is your advice in this regard? Silna, I think maybe you can take this one.
This was another one. We had so much fun this morning already. I mean, we haven't even had. I've only had one cup of coffee yet, Bruno. I don't know. Have you had coffee yet?
I haven't had any cup of coffee.
Yeah, no coffee yet either.
This is how it works. So, so this was one of the other things we argued at length. The thing is, to do an inspection at this stage is definitely not allowed by an estate agent, because remember, estate agents, unfortunately, guys, are not allowed to function under level 4. So an estate agent can't do the inspection. But remember, the intention of the regulations at this stage is for nobody to move around. So the one person with a valid permit issued by a magistrate, guys, the police is only allowed to issue permits to travel for funerals. So if there is extraordinary circumstances that would allow a tenant to move, so he does have a valid permit issued by a magistrate, there we would like to see an agreement between the landlord and the tenant to either do a virtual inspection or to only do the inspection, arrange the inspection to be done at the end of level 4. The Rental Housing Act does specifically say that the inspection must be done within 3 days prior to termination. But we need to appreciate the National State of Disaster, and the Disaster Management Act does allow regulations to supersede any other legislation. So it's difficult because the Rental Housing Act didn't know about coronavirus. Lucky Rental Housing Act. So they obviously didn't think about a circumstance where you cannot do an inspection. So what we want to see then is agreements in writing, so an email between the landlord and the tenant agreeing to do the inspection only when the agent is allowed to do the inspection. I must say, Bruno, I don't know if you agree with me, but even the landlord, I don't think it would be safe to do the inspection. Potentially, after the tenant is out, the tenant can maybe complete the inspection form, and potentially, because that is the property of the landlord can then attend to the premises. I'm sorry, I'm only thinking about this. We didn't even discuss this before the time, but would the landlord be allowed to, once the tenant is out, to enter into the premises, do the inspection, compare notes afterwards? Is that a potential solution?
Sure. Well, look, I suppose again it comes down to the restriction of movement. Would a landlord actually be allowed to drive over to the premises? What's the purpose? And theoretically speaking, in terms of the regulations, I know that I've seen people drive across the street, or like a block away. It's not allowed, but they do it. They're doing it anyway. But like me, for instance, I've got a property that I own in Pretoria North. I wouldn't be able to drive all the way there to go inspect this property. So I think the restrictions of movements would probably not allow the landlord any right to drive there. But I do agree with you. And especially now, there's no reason why we can't do virtual inspections. For the most part, everyone's got a phone. For the most part, they have data. It's not particularly expensive to just do a virtual tour of the property, switch on a couple of taps, and kind of take it from there. I suppose it's the best that we can do in the circumstances.
Yes, I agree with you. And as we rightly said, because the parties are struggling with inspections, there is a potential solution where the parties can agree, and only by agreement, to deal with the deposit in a specific way. Potentially, by agreement between the parties, hold a portion of the deposit in case there was something they missed, because a virtual inspection and a real inspection is not the same. Where you raised a valid point about the tenant potentially being forced to leave a portion of the deposit, and we don't feel that is in line with the provisions of the Rental Housing Act. Absolutely. So only when the parties agree without the tenant feeling, I'm going to use the word bullied, without the tenant feeling bullied, that was your word, for the landlord to hold a part of the deposit still until such a time that the inspection can be done. I think we're comfortable with that position.
Yeah, absolutely. So I don't know if most people would know this, but with a lot of the with our common law and the way that we approach contracts, although our system allows for the parties to contract at will, there's certain relationships, especially labor relationships and rental relationships, where the government has had to step in order to avoid situations of abuse. So someone with more power, for example, a landlord or an employer, forcing someone with less power, a lessee or an employee, to enter into agreements. So the problem with the deposit that Silna was mentioning is, if we tell a tenant, well, we're keeping a portion of your deposit because we feel there might be damages, it goes against the purpose, or it goes against the purpose of the act, because there could be a level of bullying involved where the lessee doesn't have a choice, and now half the deposit's being kept. So what Silna and I were suggesting was, be very, very specific. These are weird, very uncertain times, so be careful, but also be very specific. Do an inspection anyway. Try to the best of your ability to justify exactly why certain amounts would have to be retained. Kind of reach agreement, put it in so it's not just I'll keep half because I don't know. Try know, like do your best to know, so that if half is retained for some reason or another, at the very least, there's a proper justification for why it's being done. Not just the in the air 50% all around application, because that would probably be seen as bullying a tenant to do something they might not be comfortable with.
Yes, I agree with you, Bruno. And also, I like the way you say everybody has to do their very best within the limitations to find solutions. To just say, you know what, I don't like a virtual inspection, so I'm going to keep the full deposit. I agree with you, that's not reasonable between the parties. I like the way you've said it. Try your very best to find a way.
Okay, fantastic. Then obviously quite a positive one is Regulation 19, which would be the prohibition moratorium on eviction. Regulation 19 now says that a competent court may grant an order for eviction in terms of ESTA or PI. What exactly does this mean? Can we now evict people from their premises? Bruno, maybe you want to
Sure.
answer this one?
So again, this is another topic that we had a debate over, but I think there is a fair amount of agreement here. So the reality is that at this moment in time, the court directives allow for us to bring certain applications before the court. So that's something that we're already positively looking towards. The moratorium spoke about evictions, and I think this is something that we might just need to clarify what having an order granted means versus what executing the order means. So with the regulation, the way that it stands at the moment, we can approach court. We can ask the court for an order. All an order means is that a judge or a magistrate would say, fair enough, you've got a good case. I'm going to allow you to evict the tenant. Now, when can this eviction actually take place? That's a different story. So the date of the eviction, what date will the magistrate allow? In terms of these regulations, what they're saying is you can get the order, but you can't, the date on which you can evict mustn't be during this level 4 lockdown period, which means that it would only be afterwards. We don't know when that's going to be. And the sheriff wouldn't be able to actually execute this order until then. And execution means the actual attending the premises, possibly with the police, to forcefully remove someone. So that at the moment for residential properties has been stayed. So one cannot execute. However, you can get the ball rolling, you can get to court, and you can get that order in the meantime, and then just pen the execution for now.
Okay, yes. Fantastic. And then, sorry, Silna, you wanted to say something?
Yes, so that's very exciting. And the reason why we are happy about this is this gives us a very clear indication of the intention of the regulations when it comes to illegal occupation. Nowhere, even with the restriction of movement, the government's intention is not to place an obligation on a property owner to provide accommodation to another private citizen for free during this lockdown period. And I think this is important to appreciate. The moratorium on evictions and still the execution of evictions is to keep everybody safe and to keep the spread of the virus as low as possible. So as long as we know the regulations only allow for these evictions by court order. So as we've always known, no arbitrary evictions was ever allowed. You're not allowed to lock someone out. You're not allowed to move a friend in to motivate the guy to move out. That has never been allowed, but now even more so. So the landlord that now currently try to do an arbitrary eviction, you will definitely be at risk for going to jail for 6 months. And I think this is important to know. So even though we can get the court orders, even if the order then says that the illegal occupant must vacate, the occupant can still only vacate at the end of lockdown level 4. And this is very important. So tenants that are currently trying to rely on all sorts of weird and wonderful things to not pay rent must be aware that you can be placed on terms. The lease agreement can be cancelled in this time. We can even get the eviction order. And I think, Bruno, we've been talking so much about people talking to each other, finding middle ground. So the landlord has to appreciate as well, the tenant that approached you now that says he can't pay, try to find a way instead of just rushing to court. But the tenant that is not trying to find a way to resolve the matter, that refuse to communicate with the landlord to find middle ground, that tenant we can evict at this stage, and we will execute those orders at the end.
Absolutely. I think, unfortunately, what I notice now, especially on social media, is there's a lack of awareness as to what, like the responsibility to pay rent. So some of the tenants now are thinking that they're entitled to some kind of remission, right? Which obviously they're not. But the realization is, oh, what's the worst that'll happen? They can't even evict me. There's a lot that can happen, and people need to start realizing that this is serious. Like, it's a real life, you entered into an agreement, it's a real life transaction that's taking place. Have tenants, for example, thought about small claims court, the actual collection, right? Magistrate's court summons being issued, rental collection. But let's say the landlord doesn't want to go through that effort. Or goes through that effort and gets a judgment, but doesn't go out and collect. Listing of a judgment against a person's name. All of these things can happen, and they will lead to some sort of hardship on the tenant at some point or another, which doesn't have to be the case. If the tenant at least approaches the landlord and there's a sympathetic ear and a good conversation to be had, I doubt the landlord's going to go and issue a summons against the tenant. But if we come out with this, no, we're not paying anything, we don't care anymore, evict us if you have to, the reaction you're going to elicit is a judgment against your name, and then in a few years' time, all that hype, and it's gone. And now you have to try and pay the debt off anyway, and because you won't be able to get any credit anyway. So people need to realize there are real consequences to this.
Yes, I agree with that. I think it's a very important thing to realize.
Yeah.
And then also for eviction orders that were granted just before the lockdown. So now those are also those you cannot be able to execute until the end of level 4, whenever that date will come. I'm correct in believing that. Fantastic. Yes, and then this also applies, because I can see Regulation 19 specifically refers to a ESTA and PI evictions. This is obviously applicable also to commercial evictions.
Yes, so the conversation we had, we have already seen the practice directive. So I think this is important for people to understand that the regulations are a blanket thing, and then every single industry organization has their own internal things as well. For instance, we from the Chief Justice and from the Judge Presidents, we're getting our practice directives. that tells us how courts will function. So from the practice directives we've received, I think, Bruno, am I correct? It's dated 26th of April, something thereabouts.
I think so.
And that practice directive from the Judge President for North Gauteng, and it seems to be quite similar in most of the high courts, we will be able to function with the majority of normal litigation, applications, trials, criminal matters, civil matters, pretty much your usual running of the courts. We will do most of our hearings virtually, which will be weird, hey? We have to be robed. Can you imagine? My cat's going to judge me so hard. Like, if I suddenly walk out with a bib and a robe, I probably have to, for an admission of one of my candidates, to tell you that's where my cat's going to judge. So we're going to be heard over Zoom. So most evictions, I do suspect, will be granted over Zoom because it's on application, can be done on paper. So that's an interesting thing. And because it relates to all those matters, Rowan, we do believe the moratorium that we had was specifically, it said, for all residential property. And now we believe the reason why it refers specifically to Pi and Esta evictions is to say, okay, cool, those residential evictions we can do. Execution will be stayed until the end of level 4, but we can proceed on that. So we do believe that even though we were able to obtain eviction orders for commercial property, even during theoretically lockdown, but it wasn't an essential court service, but there wasn't a moratorium on those evictions. So it never had to be lifted, if it makes sense. So in terms of the normal court process, we will definitely be able to do commercial evictions as well. Once again, with execution potentially being possible in level 4 because there's no specific moratorium.
Yeah. So now I suppose the difficulty is just getting the sheriff's officers to share the same view. So this might be a situation where every attorney, every office, every area might have a different approach to this. So yeah, this opinion is subject to the actual practical application by the different individuals. And also just to maybe pay tribute to Greg, our colleague that couldn't make it this morning, something very interesting. So it's not in the regulations, but yesterday while they were doing the press conference, she did specifically mention building hijackings and that people should not be taking over buildings or any form of land. It will not be allowed. And then she specifically even made mention the courts will look at that matter. So there's something to that. So I can't comment because it's not in the regulations itself, but we can already see where the government was going with it and trying to say, look, this is the moratorium, this is how things are being dealt with. But I do feel that with building hijackings and that sort of thing, Greg would probably know better, but I think the approach might be slightly different. The courts might actually be able to grant orders and there may be execution. But I don't want to overstep there because that's more Greg's side of things.
And I agree with you, Bruno. I think that's why Greg's not here. I think he's executing an order. I do agree with you. I think on special circumstances, the court might make a slightly different order, once again, in extremely unique circumstances.
Yeah, in the city buildings, that sort of thing.
100%.
Yeah, absolutely.
Great. And then lastly, guys, the deeds offices. How are they going to be functioning, operating? Who would like to take this answer?
Sure.
Bruno, you look ready. I don't even want
to. The reality is, at this moment, it's 10 to 10, and I've got no idea. I spoke to my conveyancer yesterday. I spoke to Silna today, and the difficulty is the deeds office is going to be functioning. Yay, that sounds great. The problem is the deeds office doesn't function in isolation. The deeds office requires a whole range of services. So body corporates would have to be functioning because there's clearance certificates that are issued by body corporates. Municipalities need to be functioning. And yes, they speak of essential municipal services, but are clearance figures essential municipal services? We don't know. So our municipal office is going to be open. So there's a whole range of ancillary services. I'm not going to go through each and every one that requires the deeds office to properly function, especially for transfer of properties. So sure, deeds office might be open for searching of deeds, for maybe even lodging some sort of endorsement against a title deed. As Silna correctly mentioned, registration of anti-nuptial contracts could probably start taking place now. So there are other functions to the deeds office, sure. But these aren't the vital functions that we actually look at the deeds office for. Property transfers are. And to transfer a property, there's a whole range of stuff that we might not be able to do. So I'm not particularly sure that the opening is going to have the effect that we want it to have, unless everyone else gears up and yeah, well, gets moving.
Yes, exactly. And like we've discussed, theoretically, the municipalities, we will start seeing actual feedback from them regarding rates clearance in the next few days. And there is a chance, similar to what we've discussed on sheriffs, that every sheriff's office and every municipality can potentially apply the regulations slightly differently. So I think that's the joy that we are currently faced with. As much as we can potentially get the Sheriff Joburg South to execute an eviction order, the Sheriff Roodepoort might feel slightly different about it. Same as much as Ekurhuleni might be in a position to issue rates clearance. Steve Tshwete might not. So every municipality might apply this differently. So I think patience, guys. We can say, if there's one thing we can say about COVID-19 is, if this virus doesn't teach us patience, I don't know what it's going to teach us. but patience is a virtue.
Yeah, absolutely.
Exactly. Well, thank you so much, Bruno and Silna. Really appreciate all your help on this. I will not ask any questions about the prohibition on alcohol and cigarettes. I'm sure you're one of the many South Africans that are licking their wounds.
Yeah.
But thank you so much for your, especially the attorneys. Thank you so much for your assistance in this. Anyone who's watching this, please question, comment, put them down below, and we'll be able to get back to you. We have our Wednesday workshop next week as well. So please, if you have any confusion, please let us know and we'll be able to get back to you as soon as possible.
Cool. Awesome. Thanks.
Great. Thank you so much, guys.
Thanks.
Thank you, guys.
Have a great long weekend.
Yeah, oh, what is that?
Yeah.
I feel like this entire month has been a long weekend.
And good luck, Bruno, with us figuring out what we can and what we can't do. Hey,
it's going to spend the whole day speaking about this topic.
Yeah, that's exactly it. But yeah, thank you, guys, and still remember to stay safe, everyone.
Awesome. Cheers, guys.
Exactly. Thank you so much. Thanks, Bruno. Thanks, Silna.
Pleasure. Bye bye.